It is another tracking week. Welcome to this week's edition of the Tracker, a program that highlights issues that affect our society. What is our focus this week? Before the introduction of the Administration of Criminal Justice Act 2015, Nigeria's compliance to human rights issues was very low. And to address this challenge, Administration of Criminal Justice Act was introduced and domesticated by some states of the Federation as a law to ensure that the criminal justice system becomes more efficient and, of course, more responsive to the rights of the people. So, on this week's edition of the program, we shall be examining some of the provisions of this act as regard arrest, detention and treatment of suspects, and, of course, bail. My name is Richard Ilesomi. Please don't go away.
The quality of a country's criminal justice system is a reflection of the integrity of not just those saddled with adjudicating over trials, but also of the entire structure put in place for the proper administration of justice. Development watchers even believe that for any country to experience economic growth, such a country must at least first have a functional judicial system that will lure local and foreign investors and at the same time guarantee a conducive environment for businesses to thrive. But before now, this could not be said about Nigeria, which has a discouraging history of slow dispensation of justice, as trials could remain in court for as long as 10 years without making any progress, with all sides exploiting the loopholes in the laws. Incessant adjournments, interlocutory applications, poor case management, and most importantly, flagrant disrespect for human rights reigns supreme in the country's judicial system. And to address all these lapses with a view to making criminal justice delivery more progressive, the Administration of Criminal Justice Act was passed in 2015 to significantly alter the criminal justice process with a prime aim of engendering efficiency and effectiveness in the quality of justice delivery in Nigeria. The Act, which has been domesticated in some states of the Federation, was envisaged to be a paradigm shift from the inglorious days of flagrant disrespect for the rights of citizens.
The law is trying to regulate the imbalances in the criminal education in Ondo State. As we all know, the police officer, most of the time when they go out for arrests, they don't seem to recognize the law. And most of them most of the policemen that go out for this operation, they are not professional because they don't have the wherewithal to investigate the matter. So most of them, out of personal they try to prosecute out of jungle justice. So the law is meant to normalize the procedure of if there are criminal cases, the process it will take, so that people will not fall victim of all these police extrajudicial thing. So the act is to normalize everything.
Now, the Administration of Criminal Justice Law of Ondo State 2015, it's the recent law that came to take care of prosecution or administration of criminal justice, basically, in Ondo State. The law is a product of this office, the office of the JDPC, and the office of the Honorable Attorney General of Ondo State. Back then, it was a collaborative effort between our office and his office. So, and it's an innovative law. The law did not specifically change from what we have under the criminal procedure law of Ondo State that was in existence. A suspect, basically under the Police Act, a suspect can be arrested without warrant where he is caught committing the crime, and then probably or immediately after, or where he's arrested and he escapes. In all those instances, he can be arrested without warrant. And then the suspect, if arrested, with warrant. He should be treated humanely. He shouldn't be beaten. He shouldn't be handcuffed, except he resists arrest or for his own safety, and some other things like that. So the law is basically to the effect that administration suspects should be treated with dignity.
According to, I think, Section 5 of the Administration of Criminal Justice Act, a suspect, even when arrested, should not be, no unnecessary force should be used in arresting. Yes, the only person that can be unnecessary force should be used is maybe somebody that is trying to evade arrest or somebody that is in the actual course of committing the crime. But for our security system, or the police and all people that are supposed to be in charge of enforcement of justice, they are the ones that actually go outside their scope of duty. Because according to Section, I think 6 of Administration of Criminal Justice, a person, I think 8, a person should not be subjected to inhumane treatment. Arresting someone and beating the person in the process of arrest is treating the person as a criminal already, and everybody is presumed to be innocent until otherwise is proven. So you can't arrest somebody and subject the person to inhumane treatment because you feel like you have the duty or you have the power to do so. It's a breach of their fundamental human rights, and such is liable to punishment by the law. The major thing for people to know first is to know their rights. Every individual, every citizen in Nigeria is entitled to know their rights as a citizen. I have a right to be heard. When I am arrested, I have a right to be informed of the reason why I'm being arrested. I have a right to be treated as a human before taken to the police station. I have a right to my lawyer. I have a right. So if everybody know their basic rights as citizens of Nigeria, they will be able to talk when they are being treated differently.
In Nigeria before 2015, the two basic legislations dealing with criminal procedure were the Criminal Procedure Code and the Criminal Procedure Act, passed down to the country by the British colonial administration, but both have become outdated. These laws have been enforced since 1945 and 1960 respectively, without significant improvement as such. These obvious challenges of the criminal justice system led to the enactment of the Administration of Criminal Justice Act in 2015, which was believed to be an important landmark in Nigeria's criminal justice reform process. It is, however, disheartening that 4 years after the birth of the Act, not much seems to have been achieved in the area of implementation, with the challenges adduced to the discouraging level of awareness about the Act amongst the civil populace and the criminal justice agency, whose service delivery and efficiency the Act seeks to improve. For instance, the Act makes provision for how a suspect can be arrested, detained and treated before being tried by a court of competent jurisdiction. Under the law, a suspect is presumed to be innocent until pronounced guilty by a court of competent jurisdiction. What this implies is that such a suspect is accorded a full respect required of a responsible citizen, notwithstanding the weight of the alleged crime committed. But in Nigeria, reverse is the case, as suspects would have been inhumanely treated, even beaten black and blue to make confession under duress against the provision of the Administration of Criminal Justice Act. Another critical provision of the Act is bail, a security given by the accused that he will appear and answer before the proper court the accusation brought against him, and includes a bail bond or a personal bond. Specifically, Part 19 of the Act makes general procedural provisions for bail, while Sections 30 and 31 of the Act make succinct provisions for procedures to be followed by the police in granting administrative bail to a suspect. Most importantly, bail is to be granted at no cost, and that is why it is written in most police stations that bail is free.
Bail is free to all citizens of Nigeria. But in practical sense, we have had series of instances, but not reported to our office, that upon this law, the police still go ahead to collect money. Some of the unscrupulous ones in the police still go ahead to collect money before admitting suspects to bail. But my position here, if such matter is reported here, we will take exception to such situation. And what I would have done personally is to petition the Commissioner of Police. After doing that, ask for damages. And at the same time, I will take effort to sue whoever police officers that are involved in this thing, so that it will embarrass the police and serve as a deterrent to police officers that are found of collecting bail from people.
When we make arrest of any suspect, we treat them in line with the best international practice. Once we first bring that to the command, we hand over that to the investigating officer, who will do the needful by conducting interrogation. We have an interrogation room, so the suspect will be interviewed, taking the statement, and after taking the statement, he'll be given a bail condition, all within the short period of time. What I've mentioned so far, within 1 hour, 2 hours, everything is done. He'll be given a bail condition, so he'll be allowed to call his relative or his lawyer that will come and perfect all the bail conditions. And once all those conditions is met, we allow him to go.
If you look at Section 33(6) of Nigerian Constitution, everybody is presumed innocent until it is proved in court. That is to tell you that if somebody, even the person that is caught in the act, it is still presumed to be innocent. So, ipso facto, if a suspect is taken to the police station on any offense, for any offense, he or she is entitled to a bail. And that bail is just a recognizance, a written recognizance, saying that as long as this case lasts, I will be reporting myself. And if I do not report, there is a bond to be forfeited there. In that bond that you are signing, there could be certain amount of money there in that bond. And that money you are signing there will only be the surety, that is the person standing for you, who could only be made to show cause, or only be made to, to act according to the dictate of that bond if the suspect elopes or absconds. It is wrong. It is not just wrong, it is criminal for anybody to ask for money before granting bail. And if you are found in such situation, we've always given out the numbers of our officers. You seek audience with the DPOs. If they do not allow you to see the DPOs, you can call the headquarters here. It is just that some of our people did even encourage this type of situation. For example, you see parties in a case, even before a suspect is detained, you see them asking the police how much they will have to pay. Some that are highly educated, but we will continue to, re-echo it, continue to let our people know that it is criminal, it is unacceptable for anyone to pay at the police station before a suspect is allowed to get bail.
I am not a lawyer, but I'm aware that the law says that if anybody is arrested within 24 hours, he has to be arraigned in court for prosecution. Otherwise, the person should be let go. The person, if they can't arraign the person in the court, the person has to arrange for someone who can sign surety for him as a bail that is not going to escape. And based on that, he will be released on bail. More so, the bail, if you get to the police station, you see written all over the place that bail is free. Unfortunately, so it is not free. I have had my personal experience where I went to secure the bail of somebody, and after signing all the necessary paper, I was waiting for them to tell me, to release the fellow to me. I waited, and after about 1 hour, and I requested to know why I was still waiting, and somebody said, "Oga, you never talk now." I said, "Talk what?" You say you never talk. If you tell us how much you want to give to us, I say I'm not going to give you anything. Hey, he said, "Okay, I should go, that they are not going to release him." I said, "If you like, detain him here by tomorrow. I'll go to court and secure his bail." That there's no big deal in sleeping in the police station. But our people are too impatient to see the law itself taking its course. So this is one of the problems we have with dealing with the police. In the ideal society, that is how bail is supposed to be, free in the police station. Now I want to tell you that when you get to the police station, the policeman will tell you the paper for writing statement. He will tell you that he bought it with his money. If you go to find out, you discover it is true. The biro is using to write, he will tell you he bought with his money. And most of the other things that are required to keep his job going will be done by him. If he's going to arrest a suspect, he will either take his money or force the suspect to pay. So these are some of the reasons why you cannot totally blame the policeman for doing that. Now we are aware that every year the federal government allocates a certain amount of money to the Nigerian police. It is only, I want to say only, I stand to be corrected, there is only in the Nigerian police force that you see them get allocation and the allocation does not go down to do what it ought to do.
To prevent this human rights abuse of some sort, the National Human Rights Commission and the Office of the Public Defender say they are all out to help those whose rights are being trampled upon.
I want to advise that if such things happen, the victim should report to people that cannot, especially people that cannot afford the service of a private legal practitioner, should report same to this office. But people that can afford the service of a private legal practitioner should go meet their lawyer to mitigate against such actions.
Our office has been put in place to fight for the unjustly treated people that will feel that their rights are being breached or is likely to be breached. We are being put in place to fight for their rights. So if anybody is in that situation at the moment, they can as well just come to our office because we are out here to protect them. Forgetting the fact that we are government establishments, but our first duty is to the citizens of Nigeria. We take up pro bono cases, we take up when they bring complaints to our office, we follow it up. The ones that are outside our scope of business, we refer them to the maybe legal aid or the better ones that can handle it. So yes, we are here to help and assist.
In addition, the Act provides for alternative sentences other than prison custody, such as community service and suspended sentence as a way of reducing prison congestion. One of the purposes of the Act is the enhancement of speedy administration of criminal justice, but delay has over the years no doubt been a major impediment to effective and speedy dispensation of justice in Nigeria. One major resultant effect of these delays is overcrowding of prisons across the country. According to the Nigeria Prison Service, there was a total prison inmate population of 75,544 as of November 2018, and of these, only 24,403, which accounted for 32%, were convicts, while a disproportionate 51,141 amounting to 68% were awaiting trials, thus making prison congestion a national embarrassment. A 2017 report by the National Bureau of Statistics revealed that Lagos State prisons, whose capacity is for 3,927, aboard 7,396 as of 2016. And similarly, the prisons in Kano State, constructed for over 2,000 inmates, had over 4,000 in place. And so for Rivers State prisons, contained over 4,000 as against over 1,000 inmates.
It is a matter of fact, and facts are undisputable, that our prisons are not really conducive. Without mincing words, they are not really conducive, even though we don't have a perfect system yet. We are also trying our best to make it conducive for the inmates, so that we can carry out our stipulated regulations and duties as being stated in the Constitution. We are having a growing society, and once you have, once the society is developing, the population is increasing, you can't rule out crime. Crime will always be prevalent. And most of our prisons were built in the colonial eras. But thank God for the current administration and even the past administrations. They have really tried in building more, recent and more befitting prison facilities for the convicted and for their awaiting trials. And presently, the present administration they are doing their best in putting up new cells. Let me take Ondo State as an example. The prisons that we have in Olokuta, medium security prisons, the place is actually meant for 180 at the initial stage, but now the capacity has been increased because more cells have been built, even though the number still outweighs the facilities we have on ground. But at the same time, the situation is not like as it used to be. There is appreciable improvement in the prisons now.
The Administration of Criminal Justice Act made some innovative provisions aimed at solving the problem of delays in criminal trials, and these provisions have been put in place to ensure, amongst others, speedy trial and quick disposal of criminal cases in the interest and as a right of a suspect, the defendant, the victim, and the fact society at large.
There are some categories, there are some offenses that can be profiled in magistrate courts. So once those matters comes in, the magistrate court may not be able to assume jurisdiction on those matters. So the best option is to remand pending the time there will be legal advice from DPP. And in that process, you will have those inmates being, dumped at the prisons, waiting for legal advice. And all these things happens day by day, every day. So Administration of Criminal Justice Act now looked at these challenges, and they felt that what is the best practice, that is applicable in modern world? How do we solve issues like this? How do we resolve challenges like this? How do we put an end to, congestions in our prisons? Until we are able to address or put into proper practice the provisions of Administration of Criminal Justice law that we have by, arrest, because in Lagos it's practicable, at least to some extent. In Lagos, once you are arrested and you are being detained and you are being remanded in the prisons, and you are, as a prosecutor, you are unable to adduce evidence within a period of 21 to 30 days, that particular suspect, defendant, must be brought to court. If the police or the prosecutor fail to adduce necessary evidence to indict or to prove beyond the court of competent jurisdiction that this particular defendant had actually committed this offense, you have to release the person. The person must be released. So you can't continue to keep people, you can't continue to keep people forever, even for offenses they have committed or not. Because for you, he who has sat must be able to prove.
The Administration of Criminal Justice Act was signed into law in 2015, a bid to revolutionize the administration of criminal justice in Nigeria, and its compliance, according to this stakeholder, is very key.
The provisions are well encoded to discourage the abuse of office of the police.
Even before the advent of Administrations of Criminal Justice Act, you do not have any right to torture. It still boils down to what I'm saying, that it is in our constitution that every Nigerian has right to his dignity of a human person. You cannot just say because you want to extract an information from a suspect, you want to force him to say what ordinarily he does not want to say, or you want to torture him, or you want to harass him in any form. No, when he says he's not going to give any statement, you don't need to batter him for that.
That wraps up the program for this week. Next week is another time. Goodbye.